The Legal Directorate of the Indigenous People of Biafra (IPOB) don accuse federal government say na lies dem dey tell against their leader Nnamdi Kanu. Welcome country people to Synod Media. Abeg, if you never subscribe to our channel, make you do so now. Make you put on your notification bell. E go ring as we drop updates. Make you like, comment, and share our videos. The Directorate of Legal Affairs, Research and Global Communications of the Indigenous People of Biafra (IPOB) don issue one strong-worded statement wey e dey clarify say wetin federal government dey do against their leader Nnamdi Kanu na deliberate misinformation, legal inconsistencies, and media distortions. E say na all those things na surround the ongoing trial of Mazi Nnamdi Kanu. For one statement when Onyekachi Ifedi Esquire sign, the Directorate don assert say no credible case don come against Nnamdi Kanu despite over 4 years of prosecution and multiple amendments to the charges. According to am, the victims dem wey dem dey call dem no get names, no forensic evidence, no direct testimony wey dem don present to link Kanu to terrorism or incitement. According to the statement, the group come further dey claim say the prosecution dey rely on laws wey dem don since repeal, including the Terrorism Prevention Act 2013 and the Customs and Excise Management Act (CIMA), when e dey claim say no longer form a valid legal basis for the charges. The statement can also dismiss as legally incompetent the federal government charge say Kanu illegally import a transmitter for 2015 to promote terrorism. E can argue say no customs document or proof of concealment dem submit for inside court, and say the charge sheet e dey procedurally flawed, e lack proper endorsement when they amend am. E con dey reference a 2017 ruling by Justice Binta Onyako. The group dey insist say IPOB, wey stand for the indigenous people of Biafra, say no be unlawful society. The ruling wey she make for open court when both parties present, they never overturn am. So the subsequent proscription of IPOB by the federal government, e con claim say they obtain am ex parte without the group representation, and e say that move, the statement con argue, e say e violate both Nigerian constitutional guarantees and international legal standard. On EndSARS allegations, the Directorate can push back the efforts to link IPOB or im leader to the EndSARS protest. E say such claims na false and defamatory. E can cite findings from the Lagos State Judicial Panel of Inquiry when e point fingers at Nigerian security forces, not IPOB, for the violence and fatalities when e occur during the protest. Can they reiterate their long-standing claim say the Kanu extraordinary rendition from Kenya to Nigeria for 2021 say e dey condemnable and illegal abduction when e violate both domestic and international law. E con draw comparison with the landmark Diko versus State 1984 case, where the Supreme Court of Nigeria con discharge a northern Nigerian man when they abduct from the Republic of Niger solely on the ground say im extradition dey illegal. Justice Garba Mohammed, who rule say Kanu dem go fit still try am despite the illegality of im rendition, e hold the Nigerian public and international community an explanation. The statement come tok, e say abi e get one law for the Sahel North, another for the Southeast. The IPOB Directorate come call on the Nigerian government to respect due process and the right of their leader, Mazi Nnamdi Kanu, to also end the reliance on repeat laws and politically motivated prosecutions, to cease the media trial and propaganda tactics. The group can also call on journalists, civil society, and the international community make dem scrutinize the case more closely and make dem advocate for justice when e dey rooted in truth and the rule of law. The statement dey come because of the growing local and international attention on the trial, with concerns when e dey mount over alleged violations of legal norms and human rights in the handling of the case. Country people, this statement from the Legal Directorate of the indigenous people of Biafra so, e sweet well and e come be like, a closing submission for law court. And, they don carefully itemize, they extray the matter from the onset. They come itemize wetin they go wish make it happen for this matter. And if you look the logic behind their presentation, it go win any case for court, because court not be sentiment, not be emotions, not the fact. Unfortunately, not be the media space now go decide the matter, na the court. And since this summary na their case for court, they don extract, so make we believe say the judge he go do his own research, and also too the facts of the law go speak when in dey give a ruling. Now for us now to wait to see how the judge go resolve this matter, to be or not to be.